wheels bending, broken rule. Hound dog howling, bullfrog croaking. Everything is broken.
Hi, I'm Matt Allen, editor of DadsDivorce.com, here with another edition of Dad's Divorce Live. Today we're joined by Dan Cuneo, an attorney with Cordell & Cordell, and we'll be talking about some of the most frequently asked Ask a Lawyer questions that come in through our site. So Dan, thanks for joining.
Thank you.
One of the most common questions that are asked to our lawyers have to do with how old does a child have to be to decide who they want to live with, if they're upset with the parenting plan that's in place and they don't want to go to mom's anymore, they just want to live with dad full-time. So how old does a child have to be in order to have their say, I guess, matter to a judge?
Unfortunately, there's not a bright line rule or a determinative age where once a child reaches this age, then he or she can decide if they want to live with mom or if they want to live with dad. Now, you raise an interesting point because you're dealing with modifications, but also we hear this when it comes time for dissolution or when you're wanting to divorce your spouse. And again, the same rule is really going to apply, which is there's no set determinative age. But what the court will take into consideration is the fact that the older that the child or the children are, then the more weight, substance, or credibility the court's going to give to that child's preference. But with the caveat being, it's really going to depend upon why do they not want to live with mom or why do they not want to live with dad. Is it because dad is more strict, dad makes them do their homework, dad doesn't let them have friends over all the time, whereas mom is, instead of a parent, it's more of like a friend? Then you're not going to really have much credibility with the court, even if you're a teenager. So that's one of the other factors that the court's going to take into consideration is the reasons why.
At what point do you know to go to the court and, ask or to let the child's decisions be made? I mean, is it enough for the kid to just offhanded say, I don't want to go back to mom's anymore? Is it over months and period of time where they say, I don't want to do this anymore? At what point do you know to go back and request, the modification? You're
going to have to allege, especially in the state of Missouri, that there's been a substantial and continuing change of circumstances from the date of the last order. Now, what is going to rise to that substantial continuing change of circumstances? Is it the fact that the child wants to now live with the other parent? You probably don't have that strong of a case, but you really want to dig deeper. Why? Are there issues going on at that particular parent's house, a custodial parent's house, that the child no longer wants to live there? Or could it be because maybe the school district is no longer accredited or isn't doing that well, or the school district that dad lives in is better, or maybe the child wants to go to high school and the high school is in dad's district.
Right.
So that could be a circumstance that would come into play for the child saying, listen, I want to live with the other parent now.
Is there ever the possibility of, if they do end up switching which parent they live with, can they switch back? Is there a lot of room for flip-flopping?
There is and there isn't. And what I mean by that is you have a parenting plan that's in place, and it's a court-ordered document dealing with visitation, the custody, and everything like that. So you have your parenting plan, and it states, okay, the non-custodial parent, whether that's mom or dad, gets the child or children on X day or days during the week and maybe other weekend. But if you wanted to exceed that and work something out between mom and dad, then that's fine. So then I guess, yes, you can't flip it.
Okay.
But it's not going to be legally binding because the document, that original parenting plan, is what's enforceable by the court. And the purpose of the parenting plan is to have something in writing, concrete, that if mom or dad can't agree on something, then it reverts back to what was either ordered by the court in the original parenting plan or what mom and dad agreed and put into the parenting plan themselves.
Another really popular question is parents are pretty fearful that their ex will remarry or get another job that would require them to move out of state, especially if there are their children involved. So lots of people want to know, can my ex move out of state with my kids?
Well, that's obviously going to affect your custody and time with your children. And so the court's going to look at it, what is in the best interest of the child or children. But it's going to really depend upon the jurisdiction that you're in. So really the first answer to that is going to be consult an attorney in the jurisdiction that you reside in, the state that you live in, regarding the potential that the other spouse may move out of state. With that being said, dependent upon the state, again, the court could look at what is the custody arrangement. Are you the residential parent, the primary parent? A lot of times the court's going to look at, okay, what is the visitation arrangement? If you're exercising a true 50-50 or close to it, it's going to be hard, I would think, for that parent to move.
Right.
Again, you're going to want to consult an attorney in the jurisdiction that you live in, but it's going to, I would think that it would be hard for the parent to say, okay, well, I'm just going to take the child or children and move in. You're no longer going to see them half the time or 40% of the time.
Right. We hear the best interests of the child standard used a lot. What are some of those, factors they take into account?
It's statutory, meaning that that's really kind of like the umbrella here, is what is in the best interest of the child or children. Then under that, it's just going to be several factors that the court's going to take into consideration. And when the court's looking at best interest of the child or children, it's going to determine whether or not what's going on at that particular time. What are the circumstances of that case? Are there any type of abuse going on, whether it be physical, sexual, or emotional abuse? If one parent wants to move, where are they moving to? Who are they moving in with? If they are, why are they moving there? How is this going to affect the other parent's visitation time with the child? How is it going to affect the child emotionally and physically? So when the court's looking at best interest of the child, it's looking at kind of like really what is in the well-being of the child. You're not going to really find, okay, best interest of the child, and here are several factors. It's just kind of an umbrella term that incorporates several different scenarios or considerations that the court's going to take into consideration.
Okay. And finally, the last question I wanted to ask, that's another frequent one we get from our visitors, is about handling your own divorce, how to draft your own motions. Do I need an attorney to represent me? I guess we explained the importance of a lawyer and what sort of disadvantage you put yourself at if you don't retain counsel.
Well, a lot of times people want to get this done as quickly and as cheaply as possible. Right. And what I kind of relate that to is you're not going to go out and shop for the cheapest dentist to do a root canal or your cheapest heart surgeon. I mean, you're going to pay for what you get. And you can look at retaining a lawyer as more of an insurance policy to make sure that you're being protected, whether it be dealing with finances or custody, but you want to know that you're being protected, because if you enter into an agreement and you and your spouse do it yourselves, and you can probably get forms at your local courthouse or online, but you want to make sure that you're following the local rules and that the courts can be able to enforce it. Because if you try to come back and modify it, some of those provisions may not be modifiable. Right. And so you want to find out what are the particular nuances and laws and caveats that are in your particular jurisdiction. So if you're trying to cut on costs or save, I still think it's in your best interest to take a document and hire a lawyer for the purposes of interviewing you, finding out what are the issues, looking at the settlement and saying, okay, well, here's what I think your risks are, here's what I think the rewards are, and here's maybe kind of in between what the court may or may not do. But I don't advise people to go into this blind and represent themselves. Right. Because you're dealing with your future, and what you do now is going to have a substantial and dramatic effect on what happens down the road, especially if there's children involved.
Right. These are long-lasting consequences you have if you don't know what you're doing.
Well, it's contractual. You're entering into a contract, and there's only certain provisions in family law that can be modified.
You want to do your own heart surgery. So.
Right. You're not going to sit there and cut yourself open or do your own root canal. Right. You want to go to somebody who's experienced and who specializes, and that, again, is another key right there, is find a lawyer that specializes in family law. All
right. Well, that'll do it for this edition of Dad's Divorce Live. That was Dan Cuneo, attorney with Cordell & Cordell. I'm Matt Allen, editor of DadsDivorce.com. We'll see you next time.